good afternoon to everybody. I hope you are having a great day thus far. We are going to jump right into the presentation for today. My name is Akua Carmichael. I am Vice President of Estate Planning and Services at Estate Stewards. Just a teeny little bit about me. By profession, I am a lawyer. I'm not currently in private practice, but over the 20 years that I've been in the estate law world, I worked as a former sole practitioner, working with owner managers as well as executors, beneficiaries, um, all kinds of individuals involved in the estate world. And I also have experience working in the insurance and wealth management industries as well. So currently in my role as vice president at Estate Stewards. I work with clients to create estate plans if they don't have them already in place. And I work with other clients where they do have a plan in place, but they'd like to make some revisions and updates. And at Estate Stewards, as some and perhaps many will know, we offer estate services as professional executors, acting under powers of attorney, trustee services, and also agency services. And we'll talk a little bit, just a teeny bit about that towards the end of the presentation. So just a little bit of a intro as to who I am, and we will jump right into the presentation. The title of today's webinar is Integrating Estate Planning into a Financial Plan. Let's get started. So just a reminder to everyone that the information provided today is provided for general informational purposes only. Please do not take this information as being given to you as legal advice, tax advice, or professional advice. We always recommend that you reach out to the appropriate advisor with your particular situation. So on the agenda for today, we are starting with a polling question, what matters to Canadians? So I'm looking for lots of participation. And then we will look at estate planning and financial planning. We'll also consider some scenarios and common gaps that appear in the integration of estate planning and financial planning. And then finally, a little bit more about estate stewards and how we can help you potentially with your estate matters. So first poll question. What do you think the top concern for Canadians is? Top concern. And, we live in a really crazy world currently. I don't think anyone would disagree with me on that. So we've got some choices for you here. What do you think the top concern for Canadians is? And just choose one. Is it affordability, cost of living, healthcare, the economy, housing, or immigration? What do you see as the top concern for Canadians? So I'll give you a couple of minutes here, a couple of seconds, let's say maybe 30 seconds to make a choice. Okay, so we've got our results. Okay, so 50% said affordability, cost of living. We had the economy coming in second, and then it looks like healthcare third, housing. Interesting. No one said housing, and then immigration 6%. Okay, interesting. So let's see what the polls actually say. So I was curious to get a sense as I prepared for this presentation as to know what things Canadians are thinking about. So Ipsos did a poll back in last December, and it was actually 10 concerns for Canadians. I just pulled the top 5. So affordability, cost of living, similar to our poll, was number 1, healthcare number 2, the economy number 3, housing, and then immigration rounded out the top 5. And the reason I pulled this, or I wanted to get this information was because, as you can see, looking at, at least 4 of 5 responses here, these issues very much are impacted by our finances. I don't think anyone would disagree with that. And so our finances matter, obviously, and ensuring that, we have what we need and we're well prepared for our current situation and the future is top of mind for so many people, for all of us, really. And so that leads me to my next slide about financial planning. And I'm sure, we all have ideas of what financial planning is. I wanted to, kind of get some sense of what people are saying out there. And so I pulled this information from the Institute of Financial Planning, uh, which gives a few different ideas around financial planning. So, first of all, personal financial planning is a way to optimize your financial situation and wealth, regardless of age and means, right? So, just optimizing your financial situation, having a plan for that. I like this term here, a personalized roadmap that outlines one's financial well-being and setting of clear goals. So a roadmap, where you are and where you want to get to financially. Financial planning can help you do that. And then we can also think of financial planning as an essential step in realizing one's dreams and reaching your financial goals. And then what does financial planning actually encompass? It includes investment, retirement, tax, insurance, and estate planning. And we're going to talk some more about these issues. So estate planning is a part of financial planning. One of the things that I've noticed in my many years in this field is that estate planning, oftentimes we think of it as just a transfer of assets that happens on death. There's a very, very strong bias towards seeing estate planning as just, this is what I'm giving to, this person or that person when I pass away. But estate planning, good estate planning, having a good, robust estate plan is not just about planning for death. Certainly, having a will is important. Planning for death is absolutely important. Being as efficient as we can in terms of that transfer of assets from a tax efficiency perspective is very, very important. But it's not all there is to the story when we're talking about estate planning. Having a good, robust estate plan that takes into account one's lifespan. I don't know how many of you are familiar with that term. When I use the term lifespan, I'm really talking about longevity, how long a person lives on the earth, to 60 or 70 or 80. And then also planning for one's health span. So, in addition to the number of years that we're going to have on the earth, we are going to age in, different conditions. Some of us are going to age and, you know, die in our sleep, never have like a major disease or need major surgery or medical treatment. And others will experience significant health issues along the road and need surgery or significant treatments or hospitalization or specialized care. The issue for all of us is nobody, no one really knows for sure as they age what their health condition is going to be. And because we cannot know these things, it doesn't mean we put our heads in the sand and say, well, I don't know, so I'm just not going to worry about it. Uh, it's actually really, really important to think about planning for longer life, but also ensuring that you've got the resources, the financial resources that you need for today and for the future, and not just for yourself, but for your loved ones and loved causes. I know when we're talking about will planning, we talk a lot about our family members, the charities we want to leave things to, but it's also really important that we plan for ourselves, for our own health and our own well-being, and for those who may be depending on us as well, or people or causes that we're also supporting. So estate planning, financial planning come together when we look at plans for the future, plans for right now, and just making sure that we've got the finances to shore up whatever our plans are for ourselves. So, what is estate planning? We can spend a little bit of time looking at it. I like to think of estate planning as an opportunity to choose how you would like to have a legacy for, your lifetime, and also how you want care for yourself. Because if you don't have a plan in place, if you haven't decided what your wishes are and who you want to help implement those wishes, there is a plan in place for you if you don't have one. The government has set up a plan for people who don't have an estate plan in place. There are laws in place. They're called intestacy laws. So if you pass away and you don't have a will, if you're alive and become incapacitated and don't have powers of attorney, there are laws in place that deal with that. The issue for most people, I would say, is the way that the laws step in and the choices that end up being made on your behalf oftentimes are not what an individual, in their own right would have wanted to do. And so that's why estate planning, I think, is so important because it gives you an opportunity to exercise your free will to decide, how you want to be taken care of if you become incapacitated, who you want to leave assets to when you pass away. Those choices and decisions become significantly limited when we don't exercise them and we pass away or we become incapacitated. There's another system that steps in to make those decisions for us. And so it's really, really important to exercise that power of choice. When I talk about estate planning, I like to think of it as the power of choice. So as you can see, is one of the points here, you have an opportunity through estate planning to define your wishes and also provide for dependents. So that is, dependents are minor children, definitely a spouse, other perhaps adult children who are not able to provide for themselves financially that you may be supporting as well. You have that opportunity to ensure that you've documented and indicated who those individuals are and how you would like to take care of them. It's also, estate planning also provides an opportunity to choose the people that you want to have involved in the execution of your estate plan so that heirs are treated fairly. Of course, we can't guarantee that everybody will be treated the way they should be, but that's why when you're trying to decide who I want to make my executor, who I want to take care of me if I become incapacitated when I'm older, you're going to pick people you trust and believe are going to carry out those duties efficiently and effectively and fairly. Again, you have those choices when you make the choice to actually have an estate plan in place. Additionally, if you pass away and you don't have a will in place, you lose an opportunity to leave assets to charities. Because if you pass away and you don't have a will in place, the intestacy laws in Ontario indicate that your legally married spouse and your biological or adopted children are the people that will inherit from your estate. That's the first group of people, and then your parents and your siblings, and it kind of goes from there. But blood relatives are the only ones outside of a spouse that can inherit. And so if you don't have charities listed in your will, if that's what you want, then you lose that opportunity. If they're friends and people you'd want to give assets to, that opportunity is lost as well. Additionally, when you engage in estate planning, you have an opportunity to minimize taxes and fees that otherwise would accrue through a will. The will itself, you have an opportunity when that will is being drafted to have language included that gives the executor power to make certain elections and designations that can result in the minimization of taxes in the estate. If you don't have a will in place, you lose some of those opportunities. And so, I've never had a client in the 20 years I've been in this work, I've never had a client say, I'd like to give as much money to the government as possible when I die. Never seen or heard that. And, tax minimization is always top of mind for all of us. And so we don't want to give those opportunities away by not engaging in estate planning. Additionally, the estate can be made more effective in terms of simplifying the executor's work when information is clear, where assets are, who the advisors are that the deceased person was working with before they passed away. It just makes life a lot easier for the executor, for the people acting under powers of attorney, if you've put some thought and planning into the work, into your estate before death or incapacity takes place. So I want to spend a little bit of time now just going through some of the key elements of an estate plan. Uh, First off, when you're thinking about estate planning, knowing what you want to do is key, as I've already said, exercising your power of choice. Now, the elements of an estate plan, they actually empower the people or entities that are going to be involved in the implementation of your wishes to implement your wishes. All of these elements that you see before you, they give authority to particular individuals or entities to carry out your wishes. And so that's why first you need to know what it is you want to do in your planning, and then empower the right people so that they can carry out your wishes. So a will, I've mentioned, it's, I guess you could say it's the cornerstone of an estate plan. It's one one of the cornerstones. I would say powers of attorney are also cornerstones. And for some people, they will have more than one will. If you are a business owner, you have a business that has value in it, you may require primary and secondary wills for your estate. The benefit of having a secondary will is that it reduces probate tax fees that might otherwise have to be paid. In your will, you can also include a testamentary trust. That's a trust that takes effect upon the death of the deceased person, obviously. And it's an opportunity to ensure that assets are distributed to particular beneficiaries, individuals that might not be good with money or may have special needs, whereby the best way to get assets from the estate to them is through a trustee, another person, an intermediary who's actually managing and dealing with the assets that have been set aside for those individuals until a certain age, in some cases for their lifetime, just depending on what the situation is for any particular beneficiary. The executor and guardian, so these are individuals that are normally named in a will. An executor, I would say, probably has the most important job when it comes to estate planning. They've got to ensure that all debts and taxes are paid. They've got to deal with all the administrative issues around a person's estate. And then the executor has to, again, ensure all the taxes are paid, apply to CRA and get a clearance certificate. There's personal liability if the duties are not carried out appropriately. And of course, the executor is answerable to the beneficiaries. They've got to ensure that they've managed the estate in the best interest of the executor. So it's a massive role and opportunity, and one not to be taken lightly, of course. A guardian is an individual that can be named in a will, and it's not always going to apply as we get older. The need for naming a guardian generally becomes something that's not required. If you have minor children, or let's say you're taking care of grandchildren for some reason, they're in your care, you have custody of them. A guardian is another individual. Guardian and custodian actually are have the role of basically taking on the responsibility for minors and ensuring that they are cared for and financially have what they need. So that's another important part to be included in a will. Of course, as children get older, when a child is 18 or older, there's no need to have a guardian a guardian or custodian named in a will. Powers of attorney, as I've mentioned, are very important because they deal with what happens when we're alive but incapacitated. The power of attorney for property deals with finances. Power of attorney for personal care deals with personal care decisions like health, shelter, safety, medical treatment, nutrition, hygiene. And so, again, we tend not to spend as much time on powers of attorney as we do on personal care, on wills, but they're equally important. And it's one of the interesting things about powers of attorney. I'll just take a minute to talk about the power of attorney for property. It empowers the person named, and that individual in Ontario, their title is an attorney for property. That's the legal name of the person who's appointed under power of attorney for property. Doesn't mean they're a lawyer. Oftentimes, people will name their spouses, their children, their friends, people that they trust. That individual has the power now to make financial care decisions on behalf of the incapacitated person. But it's very, very important that uh, their powers are, if there are specific powers you want that individual to have or not have, that should be detailed in the power of attorney. And I'll talk a little bit more about that in a couple of slides to come when we look at the scenarios. A couple of other documents that I want to mention that are key to an estate plan. The living will, which often is accompanied by a power of attorney for personal care. It is an end of care. It's a document that details end of care or end of life wishes. So if there are specific treatments that a person wants or doesn't want, if they have particular desires with regards to body parts. I worked several years ago with a client who she wanted her certain body parts to be frozen, like flown to Switzerland and frozen and revived later in life. It was very unusual and different. Those kinds of different requests or treatments that a person is wanting can be detailed in a living will. A living will, you don't have to have a living will. The questions of DNR, so do not resuscitate, if doctors determine that you're terminal, whether you want to be kept alive artificially or not, that can be and should be detailed in either a living will or in a power of attorney for personal care. Either document can particular wishes. And it's important to let people know exactly what your end of life wishes are. If there are specific treatments that you want as well, that can be indicated in a living will. Also, if you don't want certain kinds of treatments, if you want certain things withheld, that should also be included in a living will. Now, with a letter of wishes and a personal property memorandum, these are documents that are not legally binding, but they can be very helpful to either an executor or person acting under power of attorney uh, in providing additional information that you would want that individual or those individuals to be aware of as they're carrying out their duties. So a letter of wishes provides additional detail for a person acting on behalf of the estate. So for instance, I have here a testamentary trust is a key element of an estate plan. If a person set up a trust for a beneficiary, let's say a parent has a child that has autism, and the trustee is going to be managing funds on behalf of that child. Maybe there are special programs that the child is involved in, or certain people that are a part of the child's life, and the parent wants to ensure that they continue to be part of their lives, or the child is, going to certain types of therapy or certain types of programs. Details around what is required could be included in a letter of wishes for the trustee. So they have some additional direction in how to deal with particular requests that are being made by the deceased person. A personal property memorandum deals with personal property. So if a person has a lot of personal property. So personal property is everything other than land, building, houses. So it's your furniture, your jewelry, your clothing, artwork, wine collections, stamp collections, watches, all of those types of things, automobiles, boats. Uh, and if you've got a number of different items and a number of different individuals that you'd like these items to go to, listing out the property and the individuals that they should go to can be done through a personal property memorandum, as opposed to having a very long will listing out all these different items. And then another key element is obviously insurance. We'll talk a little bit about that as well. Insurance can be so important for dealing with tax liability, for increasing the value of the estate. There are just so many different ways, providing funds to the executor while they're waiting for probate to come through. There are just so many different ways that insurance can be helpful, and it is quite essential in terms of elements of an estate plan. So let's look now at a couple of scenarios. What I want to do is just consider the integration of estate and financial planning. So let's look at a couple of scenarios and we'll flesh these out a bit. So you've got Richard here, who is 65 years old. He's got two adult children and a common law spouse. So his spouse he's not legally married to this person. Now, Richard has some health issues and he wants to age in place at his home. Like 81% of Canadians, I was at a presentation a couple of months back, and the stats are that 81% of Canadians want to age at home. That's the desire for most of them. Another interesting stat to go along with that, I read that in the Toronto Star the other day, was that um, only 62% of Canadians actually have prepared their homes for being able to age in place. And so that's very interesting to me. 81% want to age at home, only, um, you know, 62% have not actually, are not preparing for this, even though they'd like to do that. And so one of the things to really think about is the costs of aging in place, retrofitting of the home, like the cost to do that, in-home care. This is where financial planning becomes so important as we think about the estate plan as well. Because it's one thing to say, I want to age at home, but do financially, is that something that's realistic? Is a person going to be able to do that? And then what's required to make that happen. So for instance, with 62% of Canadians who have not prepared to be able to age at home, even though that's what they want to do, what are the reasons? Are they just, you know, unsure of where to start? Do they not have the money to do it? Do they not know whether they can afford to actually retrofit their homes or not? Are they just putting their heads in the sand and not dealing with, getting to it? It's hard to say, but if that's something that a person wants to do, it's really important to look at your financial plan to ensure that you actually have the resources, the financial resources to do whatever needs to be done to make sure your home is safe for you in your later years. If there were any medical issues and you didn't want to age at home, you'd be able to do that. I actually have an interesting story about a client that I worked with many, many years ago who lived in his home, loved his home. He was a widower. His children were all grown and living out of the home. And he was having trouble with his knees and could not get up the stairs. And so he needed to put an elevator in his home. And he had the resources to do that. But, he didn't want to spend the money. He thought, this is so much money, I don't want to spend it. But it got to a point where he couldn't get upstairs. He just could not use a significant part of the home because he couldn't get up because of the problems with his knees. And so his daughter, who is a friend of mine, said, look, Dad, just spend the money. And he did that, which was, and so he used the elevator. It was wonderful. But a few years ago, I was chatting with her and learned that he's now in a retirement residence because his health issues are such that he, can't continue living at home. So one of the other things, as we're looking at this scenario, one of the things for Richard to be thinking about, he's got some health issues. He'd like to age at home. So one of the first issues is, can I afford to live at home. In-home care can be very, very expensive. I've heard some quotes as high as $25,000 a month if you're to have consistent, round the clock care. It can be very, very expensive. So knowing what the costs are of aging in place matter for in-home care, but also being aware if there are health issues, there's no guarantee that a person may be able to age at home for the rest of their life, even if that's what they want to do. In some cases, it's not medically possible, as in the case of one of my former clients, to continue living at home. He had to go, he's now in a retirement residence. And depending on what his health situation is like, he may need to move from there to a long-term care facility because he'd be better supported medically than he would be in a retirement residence, of course, depending on what type of residence he's in and what kind of services they offer. So when a person is thinking about estate planning, for themselves, it in-home care it's great to think about that and determine whether you can afford it. It's also really important to recognize maybe that's not even going to be realistic. If there are health issues, what are, if there are genetic things in the, your parents had certain issues, siblings have certain issues, is it realistic to think a person can age at home for the rest of their life? And making sure that at whatever stage a person is in terms of their health span, there's a plan in place to deal financially. There's a financial plan in place to deal with these different stages of life and health issues so that an individual is prepared. That's really such an important part, particularly when you're dealing with powers of attorney for personal care. Now, to ensure that all of these plans can be carried out, having the appropriate estate planning documents is key. So the power of attorney for personal care and also a letter of wishes if there are specific instructions around, again, Richard has some health issues. Depending on what his health issues are, it would make sense for him in a power of attorney, in a letter of wishes to give instruction to the attorney for personal care as to, I need certain treatments, I have certain health care providers, I go to certain types of therapy, and I, want to ensure that these services are available to me. These are the people I'm working with. Because remember, when a person is incapable, there are situations where they're not going to be able to communicate to you what they need. That's, part of their incapacity. And so documenting these wishes is so important. Okay, let's look at scenario number two. And we are still in the realm of planning for incapacity. So a person is unable to make decisions for themselves. Let's look at now the power of attorney for property. So CPOA is the acronym for a continuing power of attorney for property. So in this case, it is going to deal in the realm of financial decision making. So Gina is 57. She is a high net worth divorced woman with 3 adult children. I'm going to say that Gina wins the award for the Bank of Mom and Dad representative. She is doing a lot of that work. Her kids are all hitting major milestones in their lives. So she's got one child in university, another one that's about to be married, and another one that's about to have a child. And she's, paid tuition for her kids. She's paying tuition for her adult son who's in university. She wants to help her daughter with down payment on a house. I'm sure many of you have heard of the, Bank of Mom and Dad in relation to parents helping their children make down payments on homes. That continues to be something that we're seeing with younger generations, asking parents for help with that. And then she's got another child who's getting married soon. She wants to help with those wedding costs. And because she's got a grandchild on the way, Gina's very interested in helping pay for the education or helping to fund her grandchildren's education. So she'd like to set up a RESP for the grandchild. Now, given that Gina is a high net worth individual, there, you know, it's highly likely that her plan is going to allow for her to meet all of these financial obligations and desires, right? There will be funds there. But of course, it's so important to sit down with your advisor and ensure, I want to do this for my child. I want to do that for the other, can I afford to do this? And, what, if any, limitations or parameters should I be paying attention to as I'm wanting to carry out these desires? That's so important just to make sure that that can be done and that the funds are there to do that, even as she's taking care of herself and ensuring that she has enough of her own funds to make sure that she's well and taken care of for her lifetime. And, as she ages and if she should run into health issues or have other needs, that there are funds there for her as well. So, in the instructions for all of these things that she wants to do for her children should be clearly communicated in her estate plan. And it's interesting, right? Because we think of doing things for our kids and documenting those things in our wills, right? And it's easier there because a person has passed away, the desires that you want or the things that you want to do for your kids are clearly indicated there and it can be done. But when a person is alive but incapacitated, things become a lot more tricky, especially if your children are adults. They don't have an automatic right as adults to the assets of the parent, even if the parent, while they were well, said, you know, Jenny, I want to give you, $100,000 for a down payment on a house that I know you and your partner want to purchase. If Gina were to get hit by a bus and end up in a coma, right, or be diagnosed with early onset dementia, and she's, compromised cognitively, doesn't remember. Her daughter, can't just show up and say, Mom, give me the money now, right? If she was in a situation where somebody now has to be making financial decisions on her behalf and in control of her finances, her accounts, investment decisions, the kids don't have an automatic right as adults to, any of these things that she's promised to do for them or wants to do for them. And so that's why it's so important, in addition to ensuring that the financial plan allows for Gina to do these things for her kids, it's also very wise to have these instructions and wishes communicated in a continuing power of attorney or in a letter of wishes, depending on how extensive the goals are, the things that you want to do for family members or for grandchildren are. And I'll give you an example of what I'm talking about. If, let's say, Gina does a lot of charitable giving and she becomes incapacitated. The person who's acting as the person or entity that's acting under her power of attorney, under her continuing power of attorney for property, cannot just start making charitable contributions on her behalf without instruction in the continuing power of attorney for property that they are authorized to make charitable gifts on her behalf. And the legislation is such that it's limited to 20% of her income, or her assets or resources can be devoted to charitable giving that she was doing while she was capacitated. So, it's really just to, give us all a sense that, things we were doing before we became incapacitated in terms of our financial life are not an automatic that can be carried on when a person passes away. Sorry, when a person becomes incapacitated, just because they were doing that before. The person who's going to have authority over their finances, the attorney for property, will need authorization to continue doing those things. And so when I meet with clients, one of the things I say is, if you have been involved in charitable giving, maybe you give to your church or other religious organization, or a university, or a specific organization, and it really means a lot to you, I encourage clients, make sure that you've got a clause in your continuing power of attorney for property that authorizes the attorney to continue making these contributions on your behalf because it's not an automatic thing. And with regards to one of the things I want to also make clear, with regards to a letter of wishes or a continuing power of attorney for property with this down payment on a house or a child getting married soon, obviously, if the kid's getting married in 2 months or 3 months, you don't have to whip out your power of attorney and put that in unless there are some healthcare issues and there are some concerns that in the next couple of months something, she might lose capacity, then you might want to document that. But this is more, if these are things you want to do in the future and it's not something that's happening immediately, it's a good idea to have some of these desires that you want for your kids documented in a letter of wishes, for instance. And then, having a clause in a power of attorney, a continuing power of attorney for property that provides for dependents, like the adult son would likely say he's a dependent of his mother. Having a clause that cares for dependents that's clearly stated in the document is also really helpful, and that gives direction to the attorney for property as well. Okay, so last scenario we're going to look at is Renu and John. Okay, I'm getting a message from Shelby here that we want to make sure we've got time for questions, so I will do this last scenario and we'll take a few questions. Renu and John are both 60. They've been married for many years. They have adult children. They are successful business owners. They own a Canadian-controlled private corporation, a CCPC, and they have two children. They're both adults. One child is involved in the business. Another child is not. Their second adult child has special needs. This child has cerebral palsy. This child will not be able to take care of themselves financially over the course of their lifetime because of their health issues. And so Renu and John are, thinking of retiring, doing other things, retiring from the business, and their desire is to transfer their business shares to their one child. They're thinking about, whether they do that now or through their wills or through an estate freeze. So they're looking at different options for doing that. But one of their major concerns or things that they're thinking about is they have a desire to equalize their child who has special needs. And the reason I'm talking about this scenario is I want to really highlight the issues around fair treatment and equal treatment, because sometimes parents may feel like, I have 3 kids, I've got to treat each of my children exactly the same. They have to get exactly the same from my estate, or, I'm not being fair to them. And while I would agree that with similarly situated beneficiaries, so if you have 3 kids, giving different amounts to each child can create problems and it can lead to litigation. You do also have to pay attention to each child and to their needs, right? So with Renu and John, with their child who has special needs, the child has cerebral palsy. If they were to give an equal share of an equal share of value from their estate. So, if one child gets the business, the other child, maybe through other assets in the estate, gets the same value. An adult child who's not able to take care of themselves financially, what are they going to do with, $1 million or $2 million or $5 million? That's not going to be helpful for that child as well at all. So the question around equalization, we do need to also think about what is best for the child and how best are you going to care for that child who has special needs. So the financial and estate planning discussion should really center around transfer of shares to this adult child who's already in the business and the tax liability. This is where looking at the financial plan, looking at the estate, where are the assets going to come from to fund the capital gains tax that may exist with the transfer of those shares and making sure that you're either through insurance or other estate assets, you're able to fund that liability. And then a Henson Trust is a trust that's set up for special needs beneficiaries who are receiving assets from uh, they're receiving government benefits. So in Ontario, that a lot of these individuals are receiving payments, disability payments, through the Ontario Disability Support Program, known as ODSP. Setting up a Henson Trust means that the individual can continue to receive disability payments, but also assets from the estate. So for Renu and John, they're going to want to be thinking about how much, like, how much should I be leaving for my child? Maybe not the exact same amount that they're leaving for their other child, but having the discussion around what is appropriate to care for this other child in their particular health situation. So having wills, letters of wishes, providing additional instructions are key, of course, to dealing with the transfer of the business and ensuring that a Henson Trust is created for this other child. Okay, so I want to make sure that I leave some time for questions. So I'm not going to go through all of these common gaps in estate planning. One or two that I will mention here is ensuring that well, one of the gaps that comes up from time to time is not providing adequate support for minors, common law spouses, intended stepchildren. So we hear all the horror stories of, blended families and people not getting along, but there are cases where it's a blended family and family members do get along and step parents want to leave assets for stepchildren, but for one reason or another, maybe a will was created when kids are younger and biological children are included in the will, and then there's a blended family, and the wills are not updated to include stepchildren, and then the parent passes away. And the laws in Ontario currently are that a stepchild cannot inherit without that child being specifically named in the will as a beneficiary of whatever assets are being left. So it's important to remember that. Same with common law spouses. A common law spouse is not the same as a legally married spouse. So it's important to ensure that common law spouses are provided for specifically by naming them in the will. You shouldn't just assume because someone's a common law spouse, you don't need to name them in a will. With legally married spouse, if they're not named in a will, they still have rights to a person's estate. And then for minors, again, very important to provide support for minors. There's a legal obligation on individuals to provide support for minor children. And if you don't do that, then there's a good chance the estate will be sued. Usually the Office of the Children's Lawyer will bring a claim against the estate on behalf of minor children to ensure that they receive adequate funds. And then one last one I'll look at here in terms of gaps: failure to review and update beneficiary designations. So this particularly in situations where individuals are separated and or divorced. I've seen this happen many times where a person has their first spouse named as the beneficiary on an insurance policy, they separate or they divorce, and the person forgets to go back and update the beneficiary designation with maybe their new spouse or with kids or friends or siblings or whatever. And if you don't update that beneficiary designation and pass away, your former spouse who you've been divorced from for 20 years will still get paid the proceeds from that insurance policy if that beneficiary designation has not been updated. So that's a serious gap and one that comes up from time to time. So important to review the documents. Okay, I'm going to stop. I'm going to stop there and see if there are any questions, and then I'll circle back if we've got some more time.
There were a few questions that had come in as people had registered for this session. We had the ability for people to submit questions in advance. One of which was, how do we decide on the best mix of bequests to family, friends, charity, and what are some of the specifics for single people to consider?
Okay, so that's an excellent question. And I, I was um I was thinking about that question because I actually worked with a client many years ago who was a single woman. She was actually a professional person, so she had her estate was a significant size, and she was never married, didn't have any children, but she had a number of friends that she was very close to, probably about 10 different individuals. And she had family members as well. She wasn't as close to her family members. They lived out of province, but she left a couple of cash gifts for those family members. But for her friends, she transferred her home. She had a farm that she transferred contents of her home, her automobile, a number of significant cash gifts to a bunch of different friends. And interestingly enough, her family members actually they sued her estate on the grounds that, she didn't have mental capacity when she was preparing her will. And that's why she left all these assets to her friends and not to them as her family members. And so interestingly enough, the case ended up going nowhere. The family members actually lost the case, and they actually withdrew the litigation, and the assets ended up going to her friends after all. But one of the things I would say around particularly for single people, if you're, giving gifts to friends, family members, charity, it's good to manage expectations. I think it's very helpful to communicate with family members, friends about your intentions and your wishes, because a lot of times people are expecting to get things that they're not going to get, and there's no legal obligation to tell anybody that they're inheriting anything from your estate. But sometimes it's helpful for people to have a sense of where you're going in terms of, the bulk of your estate, is not going to you, Aunt Shirley. It's actually going to my friends. Just so people manage their expectations around that. I think that can be very helpful. In terms of bequests or giving gifts to friends, family, charity, for single people, we do see a lot of singles making significant gifts to charities, and there is a lot of benefit and value in making charitable contributions from a tax minimization standpoint for the estate. So, doing things like if you have publicly traded shares and and there are potentially capital gains on those shares, instead of selling those securities, paying the capital gains, and then donating it to the charity, actually donating those securities in kind to the charity actually wipes out the capital gains tax that you would normally have to pay. So that's a real benefit to the estate. And in addition to that, if you are to name a charity as the beneficiary on an insurance policy or under a registered savings plan. That also comes with some beneficial tax minimization opportunities. Basically, if you're naming a charity under your RSP, your RIF, your TFSA, or under an insurance policy, what happens is you'll receive a donation tax credit that can be used in the year of death for up to 100%. So up to 100% of the net income of that deceased person. The donation tax credit can be used to basically wipe out the tax that would otherwise become payable. And that is also that donation tax credit also applies for where a charity is named as a beneficiary under an insurance policy as well. So instead of giving a cash gift to a charity, if you've got these registered accounts, there can be value in naming a charity and giving that $100,000 instead to a friend or a family member, and then really maximizing the tax benefits that come that way. So I would say two things: manage expectations of friends, family, and family members, and then also with charitable giving, consider naming charities for registered accounts on insurance policies. That gives you some, and publicly traded shares, that gives you some additional tax benefits.
Perfect. There's another question that's come into the chat. Can estate stewards write up a will, or should it be done by a lawyer?
Right, good question. So we at Estate Series, we don't do any will drafting in-house, but we do have relationships with a number of lawyers in the city and across the province. So if you are looking for a referral for an estate planning lawyer, please do feel free to reach out. I can certainly assist with connecting you with an estate planning lawyer in your area who can assist you, and they would prepare the will for you.
Perfect. This is another one that was submitted ahead of time. How do you set up a trust, and what are the value and risks of having one?
Right. So a trust, and I'd mentioned in the key elements of an estate plan, we talked about the testamentary trust. There's also another kind of trust, which is an inter vivos trust. So a testamentary trust is set up in your will, and it comes into effect and into existence upon the death of the will maker, whereas an inter vivos trust is a trust that is set up while a person is alive, so during a person's lifetime. And deciding on an inter vivos trust versus a testamentary trust, it really depends on what the needs are of the person that you're trying to benefit by setting up this trust. That really determines, do I want to set up a trust through my will? Do I want to set up a trust while I'm alive? One of the things to be aware of is inter vivos trusts are taxed at the highest marginal tax rate. Any income that's earned in the trust and remains in the trust, taxed at the highest marginal tax rate. So they're not the most tax efficient vehicles to use. Oftentimes, when we see these trusts set up, they're set up in the context of family trust that's usually connected to a business that the trust may own. Where maybe you've got children, adult children who are in the business, who are beneficiaries of the trust as well. Like a family trust oftentimes is incorporated with some more complex planning that usually or oftentimes will involve a business as well. It's not the only way that they're used, but it is one of the ways that they can be used. So setting up a trust really is about if you feel there are individuals in your life that uh, will not do well with having estate funds put into their hands directly. They're not going to be able to manage the money well. Maybe they're spendthrifts, or maybe they are not good with money. Maybe they're going to be preyed upon by other people that you're not happy with in their lives, where the monies you're leaving for them are going to end up, going to a partner or another person that you would prefer did not end up with your hard-earned money. Trust can be set up for all of those kinds of reasons. So I don't think there are any risks per se with setting up a trust. It's more a question of the cost of setting up a trust. They can be quite expensive, several thousands of dollars usually to have them drafted and put in place. And then there are ongoing costs around the administration of the trust and tax filings and dealing with accountants' fees and trustee fees. So they're expensive to set up, and then you've got to continue to maintain them. And then there's the high tax rate as well. So it's more weighing those issues and whether there are other more tax efficient ways to distribute assets to your beneficiaries without incurring such high costs. But in many cases, if you have minors, if you are leaving assets to grandchildren or to children and they're minors, then you should absolutely have trusts in your will to ensure that those monies go to them at a specific age, when they're no longer minors, or distributed to them over X amount of years in certain intervals as you might determine.
Perfect. We don't have any other questions at the moment, so maybe if you want to just, I think there were a couple other slides that you wanted to just quickly
Right.
touch on,
Oh,
and we can give
right.
people
So
the
in terms
time.
of key takeaways and next steps, key takeaway to consider, do I have a current financial plan, right? So do you have a plan in place? If you don't have a finance or if you have a financial plan in place, are you happy with it? Does it meet your needs currently and into the future? If you're not sure about either one of those things, next step would be to meet with a wealth steward's advisor who can assist you with creating or updating your financial plan. Next, takeaway to think about, do I have a current estate plan? So, do you have wills, powers of attorney in place? If you do, then the next question is, how long has it been since I had a look at them? If it's been more than 3 years, good idea to review them and make any updates that are necessary, required. And if you don't have a plan in place, your next step would be to work on getting a plan in place. We can, as I said, certainly at Estate Source help you and connect you with an estate planning lawyer. And we do offer a 1 hour complimentary estate planning consultation service. And then finally, does my estate plan align with my financial plan? So really important to look at, what am I wanting to do from a estate planning perspective? Do I have the funds to support these things that I want to do? And then consulting with the appropriate financial and estate planning professionals to ensure your current and future care and that of your loved ones and causes can take place. Okay. And in terms of if you have questions about the content in this presentation, here's my contact information below. If you are a current Wealth Stewards client and you'd like to benefit from estate support, feel free to reach out to your wealth advisor. And if you were invited by an accountant, you can learn more by reaching out to them about ways to be connected with Wealth Stewards.